Well, thank you. I'm not going to use my slides very much because I realize we have not much time before lunch. It's in 4 minutes. Okay, I'll use one slide then, the first one. First of all, I have a question here to everybody here. Since we talk about cross-border access, I would like to each one of you to reflect for like 5 seconds and then come with an answer. Do you know of a specific document which is relevant from your sort of cultural heritage point of view, which we have in the National Library in copyright that you would like to have access to? Please. That was 5 seconds. 1. Yes? Okay, you could buy that and you could lend it in German language in most countries. It's available, so I don't think it's a problem if you want it in German language. If you want it in Swedish language, it might not be a problem either, actually. I think, though, the director of the National Library of Latvia know of such a case of content. He was actually in Sweden and approached archive libraries they desired to have access to Swedish radio broadcasts. But I would argue that in general, one of the big challenges that people in general, researchers, the public, are not really aware of content relevant for them because it's not available. What you have online across border access is the container, the metadata. But imagine a book from the 60s, the editor thought that was a catchy title, will sell many books. It's not really telling about the content, the text, the paragraphs, chapters, if it's relevant for a user in Latvia or in Poland. This is the elephant in the room, Google, which provides full text search, which libraries do not. I think that's the first step to cross-border access, to really know, is there something in that container that's relevant for me or not? That's the first question. So my speech now, probably like less than 50 minutes, will be about these steps in making available. You have the delivery, the acquiring of documents, which is quite important. I'll come back to that from different legal aspects, because I'm going to provide a comprehensive view. You must have, as an attorney, a comprehensive view, because the legislators do not have a comprehensive view. The EU, who is the one who legislates more or less, have a view on copyright, data protection, competition law, not a comprehensive view. That's for the attorney, for the practitioner to address. And then after the delivery, you have, in most cases, if it's printed, to digitize, and then also, of course, to preserve, and then to make available. In all of these instances, more or less, you have competition law, copyright, and data protection. So we start with delivery. Wouldn't it be nice if you could have it in the digital format to begin with, the PDF file from the publishers, not the text itself to digitize? It's costly, so you have the issue about funding. There you have data protection, and there you have also copyright. Would you like to extract metadata, use artificial intelligence? Then you have copyright and you have data protection. To make available, you have, of course, data protection and copyright as well. And if you have funding problems and would like to enter a public-private partnership, you have the issue of, well, how does the different legal disciplines apply on the private partner and the library? I'll give you a concrete example from Sweden. We entered a public-private partnership with a publisher, a newspaper publisher. Rights were cleared according to the copyright scheme we have, ECL, Extended Collective Licensing. But could we argue it was actually made for preservations, and could you rely on the exception? No, because it says in the Infrastructure Directive it cannot be used directly or indirectly for commercial purposes. And it was indirectly for commercial purposes. The publisher would use it in their business. So you must have a comprehensive view. So what are about our recommendations? We'll elaborate on them tomorrow, but if you start from the beginning and look at copyright and data protection, as far as data protection, the EU regulation, which has direct effect in every member state, including EFTA countries, those exceptions that would be to be applied have to be you have to levy legislation on membership level, because you do not have them specifically in EU regulation. So that's up for you to lobby in your country to have these exceptions, primarily archive purposes, and it's this very important public mission you execute. And as far as copyright is concerned, it would be good to have a solution so you could have these, you could use these digital formats or not digitize. If you still have to digitize to make the content available, it is useful to have a scheme if you're in a public-private partnership that works, and unfortunately you cannot then rely on the exception. And you need to introduce an exception which is useful. And the one in the DSM directive that's being passed, the outer commas, is not useful because it's only to be used by the cultural heritage institution and not the private partner. So you need also to introduce extended collective licensing alongside or only rely on ECL in your country. And then to the making available, we discussed now cross-border access, and in my group we elaborate on the existing sort of best practices and how we could push the envelope. One existing best practice is from Sweden, where we provided cross-border access to audiovisual works to the University of Åbo, which is a Swedish-speaking university, using extended collective licensing. We've done the same with Malawi, just a paper pilot to prove the proof of concept. Now you have the DSM directive, the outer commerce legislation, but it only provides the right to make available outer commerce works. It means you have to do a due diligence, exclude in-commerce works, which could be quite time-consuming. And also for research, it doesn't make sense because the research would like everything. So you have to introduce the ECL legislation. Then you come to the question about cross-border access and ECL legislation, because the outer commerce legislation relies on the principle of country of origin. So you could, provide access to the whole of Europe. But how do you do with ECL? We have the Swedish best practice, and we're looking to how you could possibly streamline that further and make it more simplified to give access and lower the costs. But since the DSM directive was finalized in April, we haven't had that much time to analyze it, so it will be in the report and we could elaborate on it tomorrow. Now I have how much left? Okay, so overall, and I have to elaborate tomorrow, and we will, if you're interested, is that you have to have this comprehensive approach on all of these aspects, because if you create a solution only based on a copyright, with a copyright perspective, and miss out data perspective, data protection, you will most likely fail. And if you enter into a public-private partnership, you must have competition law also in mind, and other legal aspects. You need a comprehensive view. That's the overall message. And as far as data protection and also copyright, I would say that this project would benefit from the follow-up project on data protection, because the EU regulation states explicitly that you could approach the national competent authorities and say, we have here agreed upon in our constituency on best practice, a code of conduct. And if that's very convincing, they could also be forward that message to the European Union and possibly establish a best practice. And since the EU regulation on data protection is the world benchmark, a constituency like this one could actually achieve a global benchmark on data protection for libraries. So I think that's something that's worthwhile to pursue, because then this sort of cross-border cooperation could have real impact on global legislation, de facto legislation on data protection. Thank you.
Thank you very much. I think the ambition you set is high, and I do hope such as really cross-border cooperation can impact the global situation. Thank you very much.